Hello, Barb Teach Blade Reynolds here, blog author of Paralegal Brain the Blog, paralegal LDA of Tehachapi Court Services in Tehachapi, California, and law professor 30 years, and one of the founders of the American Bar Association Paralegal Studies program at West LA College. Wanted to talk to you about legal research and analysis. Very important subject in thinking the law. There's three spheres of legal analysis, and that is linear reasoning, analogical reasoning, and deductive reasoning. Linear reasoning involves the analysis of timelines of events, things that occurred, or did not occur over an extended period of time. And you analyze those events and the extended period of time to determine whether or not facts existed or did not exist, to prove a fact is in existence or not in existence, to support your base case that you're analyzing that time of events for. Analogical reasoning involves the analysis of case law. A case that you are reviewing to see whether or not it's similar to the facts of the case that you need that supporting authority for. That case is called your base case. And you look at that base case to determine the similarities of that base case to the facts of your case. The more similarities you have of the base case to the facts of your case, the case becomes supporting authority for your argument that you want to advance. If the case has more dissimilarities than similarities, then it doesn't apply. The third sphere of legal analysis is deductive reasoning. Deductive reasoning involves the analysis of rules of law, statutes, ordinances. You break that particular rule of law into its elemental parts. You analyze each element of that rule of law, and that's called your major case, the basic rule of law. You then, once you dissect that rule of law into its elemental parts, you look at the facts of your case to see if they fit into each element of the rule of law. If the facts of your case fits into the elements, each element of the rule of law, then that conclusion must be that that rule of law applies and you can advance it forward. If the rules of the facts do not plug into the elements of the rule of law, then that rule is not applicable to that fact pattern. Wanted to talk specifically about analogical reasoning. Before I get there, let's break down the concept of deductive reasoning to lock it in a little bit more. Take, for instance, the case of a common law battery, the trespassory breaking and entering the dwelling of another in the nighttime with an intent to commit a felony therein. So the question becomes in deductive reasoning, that's your major premise, is a common law burglary. The trespassory breaking and entering the dwelling of another in the nighttime with an intent to commit a felony or stealth therein. Was there a trespass? Was there a breaking and entering? And is in the conjunctive, therefore breaking and the entering must occur simultaneously in order for that element of the rule of law to apply. If you have a dwelling, it has to be the dwelling of another. It has to be in the nighttime that the event occurred. Well, what's nighttime? Sunrise from sunset to sunrise constitutes in some areas of the world nighttime. Depending upon which area of the world you're in determines whether or not you have nighttime. With the intent, the mens rea, the worms in the brain that I'm going into this place and I'm going to hurt somebody or I'm going to steal something, I'm going to commit some type of felony, some type of major barroom crime. To commit a felony in that house, that was your intent, some kind of felony. And if you had to kill somebody to get away with some other felony, then so be it. you intend that type of misconduct. Want to talk specifically about analogical reasoning, case law. Whether you have a case that supports your basic argument to put forth in court, which lawyers do, that base case is very important because that base case has to be similar to the facts of your case. If the facts of the base case are not more similar with the facts of your case, it just can't apply. One of the rules of cases, I should say, that I'm thinking about specifically is a case of Jauregui versus the city of Palmdale, which involves a lawsuit and a result that the city of Palmdale was found in violation of the California Voting Rights Act. And I reviewed that case because Tehachapi, my town, for the past 44 years, has been accused of some type of violation of the California Voting Rights Act, which has yet to be substantiated because the facts of the base case, which is the city of Palmdale case, are so dissimilar that it makes Tehachapi not a Palmdale defendant. Its basic legal analysis, analogical reasoning, where you apply the base case to the facts that are occurring. And we are led to believe, and others quite possibly, that Tehachapi engages in some type of discriminatory practices against Hispanic persons and populations here in Tehachapi. Well, it flies in the face of the fact that the mayor of the city of Tehachapi is of Hispanic heritage. And he readily admits that. It flies in the face of one of the city employees making $100,000 a year of Hispanic descent. We've had numerous mayors, numerous city council people that are of Hispanic descent. And the very notion that we would be accused of something like this, when all you have to do is analyze the base case, which is the Palmdale case, to the facts of what exists in plain view here in Tehachapi, it frankly makes it an absurdity on its face. But for whatever reason, these cases are finding their way up and down the coast of California, kind of like about 10 or 15, about 15, 20 years ago. They had this slew of lawyers out of Beverly Hills that were going into restaurants and finding all kinds of violations. Your sink in your bathroom was not tall enough or low enough for disabled persons. And rather than to be embroiled in a huge lawsuit, they paid protection money to just make this go away. And that's what Tehachapi is facing right now. Frankly, the Hispanic community here is just up in arms that we would even be accused of something like that. But be that as it may, it's a great prototype of how you analyze the law using analogical reasoning, and quite readily see that the base case, the city of Palmdale case, in no way applies to the facts in Tehachapi, which are in plain view, which is empirical data that makes the case completely inapplicable. Um, so that's something that is very mindful to me, and I'll keep you posted on how this case goes. But I understand they're now on their way to another small town. We only have 5,000 people here in the city as registered voters versus almost 200,000 in the city of Palmdale. That fact alone is such a gross dissimilarity that it's frankly laughable. But anyway, enjoy your day. Make today your masterpiece. And I'm going to see you tomorrow. Take care. Bye-bye.